My Lord, therefore, Article 259 3B provides an answer to the question that is before you. And my Lord, lastly, I'll read Article 259 3C, which reads, my Lord, and it says, a reference in this Constitution to an office, state organ, or locality named in this Constitution shall be read with any formal alteration necessary to make it applicable in the circumstances. My Lord, the circumstances before you were that the CJ was not available to give the directions or assign the bench. What the DCJ did, my Lord, was applicable in the circumstances. I invite you, my Lord, to refer to that provision when you'll be making your ruling. I thank you.
My Lord, I send the Speaker of the Senate. And my Lord, allow me to make very brief submissions without repeating what my colleagues have said. My Lord, allow me to start by quoting Article 145, paragraph 7 of the Constitution, to just contextualize the reasons for our application on Friday last week. My Lord, if you look at the provisions of Article 145, paragraph 7, my Lord, the impeachment of a deputy president is a serious national stability matter. My Lord, because after a vote by the Senate, in accordance with Article 145(7), the deputy president, my Lord, it says at least 2/3 of all members of the Senate, when they vote to uphold any of the impeachment charges, the president shall cease to hold office. In this case, as contextualized, the deputy president, the former deputy president, in this case, Mr. Gachagua, ceased to hold office. My Lord, look at it also in the context of Article 22. My Lord, this former deputy president, in exercise of his right in the Bill of Rights, my Lord, moved the court by way of a petition. My Lord, on Friday, that's 18th of October, 2024. My Lord, conservatory orders were issued, which, in accordance with the petition, with the respondent's perspective, appear completely problematic. And my Lord, they required immediate intervention in terms of the respondents, my Lord, moving the court. Because, my Lord, the flip side of Article 22 is that whereas you have a right to file a case in court and seek conservatory orders in accordance with Article 23, paragraph 3A, a conservatory order which is discretionary, it means you are suing a respondent. Well, that respondent equally has a concomitant right to move to court, to interfere, to set aside, to ask the court to vary that conservatory order. My Lord, the grant of that conservatory order is discretionary. So, my Lord, there is nothing cast in stone in terms of the respondent, my Lord, coming to court to make an urgent application for the setting aside of that conservatory order. My Lord, there is also nothing strange for the court in public interest. My Lord, for the court in public interest, having looked at the grounds of this application to set aside these conservatory orders, my Lord, for the court to apply Rule 3 of the Mutunga Rules, my Lord, to make a just, expedient, and my Lord, proportionate decision in terms of directions on how to dispose of this matter. My Lord, again, under Section 60 of the Evidence Act, we all need to take judicial notice of the fact that my Lord, now we have the e-filing system. My Lord, when such extraordinary matters come to court, my Lord, the court is empowered my Lord, at any time, my Lord, at any time of the day, my Lord, at any time to access the system, and my Lord, to give appropriate directions for the expeditious resolution of this dispute. My Lord, they benefited from these orders on Friday. My Lord, unlike them, my Lord, we had the courtesy, because my Lord, we saw the court orders in the social media, and we responded accordingly. But my Lord, unlike them, we were courteous enough to serve the orders which were issued by this court to the respondents. So it cannot lie in the respondent's mouth to say that they have been ambushed to come to court, to the extent that they come to court and say that we are acting under protest. We did serve them with these court orders. And my Lord, on the last aspect of that point, is that, my Lord, then this petition, who has come to court under certificate of urgency, my Lord, having absented himself on, at the Senate on Thursday for health reasons.
Lord, may I please on record
That is
My Lord, I'm just winding up, my Lord, to emphasize.
but he did not absent himself. Sickness is not absenting himself.
My Lord, I can rephrase. My Lord, I can rephrase. My Lord, this petition
as well avoid it.
Yes, my Lord. This petition.
My Lord, may I say he apologizes? My Lord, may I say this to you?
Let him avoid it.
May I say this to you?
Yeah, my Lord, I'm avoiding
May I say
actually
this
that.
with respect to you?
He has avoided it.
My Lord, justice administered without mercy and wisdom is not justice. Here you've got someone who is in his 60s, he's saying he's sick, he has cardiological problems, and we come and play it down. These are principal advisors of the government. They must be condemned.
We have avoided it. My Lord, can I now conclude?
Have you withdrawn that?
Yes, my Lord, I was making a contradiction by saying that the petitioner was able to access the court expeditiously, and the court was able to grant him conservative orders on Friday. My Lord, the same petitioner cannot then come to court and complain. My Lord, complain when, my Lord, the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, in public interest, and given the extraordinary nature of this matter, my Lord, gives directions that this bench be constituted for purpose of determining the underlying question. My Lord, the petitioner cannot probate and reprobate, can't speak on both sides of the mouth. So, my Lord, the other extraordinary nature of this matter, my Lord, is that the petitioners have filed a multiplicity of suits. My Lord, you have heard that there were 3 cases in Ikerugoya alone. My Lord, other cases, my Lord, in the public domain, Kenyans are aware that this bench has been appointed. So, my Lord, what is wrong? What is so different? What is so strange for the Deputy Chief Justice when the Chief Justice is away? Again, for the same reason, for purpose of expediency and my Lord, for purposes of laying a multiple basis for consistency in judicial decision making, for these matters to be brought before this bench by way of our directions in terms of uses being used of this matter. So, my Lord, I don't see anything extraordinary. My Lord, as I wind up, the petitioners have just simply cast aspersions to the process of appointment. There's nothing cogent. My Lord, I don't see any integrity issues with respect to the handling of this matter by the Chief Justice. I don't see any integrity issues with respect to the handling of this matter by the bench. So, my Lord, our plea, my Lord, our sincere plea is that the underlying dispute with respect to the setting aside of the conservatory orders, my Lord, in accordance with the directions which were issued, should be urgently determined, my Lord. My Lord, in public interest. Thank you.
My Lord,
Give me.
Oh,
So, my Lord, for the fifth respondent, I'll be very brief. I just wish to remind us, yes, Dr. Kamodo, I think, for the fifth respondent, for the sixth respondent now, in the new order. First, I wish to set the record straight in terms of some misrepresentation that has been made with regard to the decision cited, the Reina Conchera decision. When the petitioners were submitting, they were not aware that I am one of the petitioners in this matter, and that I am fully versed with the entire set of facts. So they misrepresented that the matter is not active. Nothing can be further from the truth. This matter is active. It was mentioned on 24th of September 2024 before a new bench that was constituted following the accession of the honorable judges who were previously dealing with it, and it is due for further mention on 30th of October 2024. So the decision remains solid in terms of its capacity to persuade you not to depart from it, because no reason has been supplied, save for the misrepresentation that it should not be utilized. Now, allow me, my Lord, to make reference to the High Court Organization and Administration Act in light of the issue that has been raised on the sittings of the court. I will briefly cite verbatim Section 10 on the sittings and recess sessions of the court, where it is couched as follows: that the court shall subject to subsection 2, 3, and 9 sit continuously for the trial of criminal cases and disposal of civil and other legal business of the court. There is no disclaimer whatsoever with regard to the time that the court should sit. So the court can sit at any point in time, day or night. Indeed, today, when dusk came, I was apprehensive that counsel for the petitioners might leave, since the court is sitting past working hours, presumably. So the point that must lad home is that nothing prevents this honorable court from sitting at any time, such that the issue of when the court sat, when the files were transmitted, when the orders were released, whether on Saturday, whether on Sunday, though it has not been shown that is what transpired, the court has liberty to sit on such occasions if need be. With regard to the issue of the empanelment by the Deputy Chief Justice, again on this account, the petitioners have misapprehended the import of Article 165(4), because what is fundamental is that there be a substantial question of law, and that question of law is certified on the discretion of a High Court judge. What that means is that the same issues that are being heard here today could have been heard by even a single judge, if at the discretion of the judge who handled the matter reasoned that there was no substantial question of law. So what the Honorable Chief Justice or anybody else capable of exercising the powers within the office of the Chief Justice does is administrative. all the High Court judges are qualified to deal with matters of such nature. All of them. So assigning one or the other is routine. It is purely administrative. There is nothing that is exceptional intellectually in terms of requiring a special exercise of powers when it comes to dealing with that aspect. So in a nutshell, I would wish that to point out that in a hurry to come to court, the petitioners even wrongly enjoined the sixth respondent, His Excellency the President, when Article 143(2) is clear that no civil proceedings can be instituted against the President. A decision that has been affirmed by the Supreme Court in the decision of Attorney General and 2 others versus D and 79 others. So the Supreme Court made an express order that the President cannot be sued. It's an order. So the pleadings that have been lodged before this court have been filed in contempt of the Supreme Court decision, and they should amount to nothing in the full and final set of facts. So I'll be seeking that the bench continues to stay put, so that as early as possible, I can seek to have the sixth respondent discharged from the irregular proceedings initiated by the petitioners, and which they don't want concluded. They want to thrust this country into a crisis. Under Article 146, there is possibility of the office of the President becoming vacant on account of various issues, either through death, which is uncertain, through resignation, because he can tender a resignation and decide that I think I've had it too much, he can tender a resignation, or any other reason that may arise. So at the moment, upon the Senate voting on the first ground of impeachment, we stood without a deputy president. So what would happen in the event we have a vacancy in the office of the president? We are staring at a crisis. We don't have a deputy president. The Honorable Speaker of the Assembly can only serve for 60 days. We don't have an IBC. So what the petitioners are doing is fomenting a crisis of monumental proportions, which we will not be able to budge about. So I humbly pray my Lord, my Lady, that you find favor in the arguments of the respondents and dismiss the application by the petitioners. Amos Ngwara.
I presume they are over. Minutes, if they are over.
But we didn't clarify one thing. I think one of my friends have been referring to the judge at the right at Justice Murima. Justice Murima.
Fellows, I grew up in Nakuru. I don't have the problem of a nail and an arm. So I know it's Murima.
Are you the only person submitting now on this?
Yes, I believe I'm in my minutes, the 20 minutes. I want to do 15 minutes. They were 20 minutes, yes. And I said I'm doing 15. Mr. Ongoya will do 5. That's what I'm saying.
No.
He asked for 20, I'll do 15.
All right.
And the Camino, because of seniority, is asking for 5. No, my Lord, I have to use 15. There were very many people who say those things. Yeah. So I need 15. I'll give Mr. Ongoya. We need 5. Camino 5. My Lord, let me start at least for one point. My Lord, my learned colleague, Mr. Ndegwa, whom I respect a lot, is saying that probably we start with 2 points raised by a learned colleague, Mr. Joseph Kamodo. My Lord, the first thing, what is it? Okay. My Lord, the first thing is that the president cannot be sued. It's true. My Lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the Constitution. So to the extent that the Supreme Court, assuming it ever said such a thing, that cannot be good law in the face of the Constitution saying everybody is under the law. Second point, my Lord, what is the nature of the proceedings? These are not civil proceedings. These are constitutional proceedings. If Article 149 of the Constitution says the President shall do this, there is nothing in Article 156 that would entitle the Attorney General to be sued on behalf of the President. Because the Constitution itself says the President shall do this. My Lord, also, if this is Bill of Rights enforcement, if the petitioners are saying the violator of the law is the President of Kenya, then the mandate of this court is to ensure the President does not violate the Bill of Rights. Nobody else can be sued on his behalf. I think we have done with that preliminary issue. Oh, and there is these issues of vacancy. My Lord, I was imagining that if this vacancy is troubling anybody in Kenya, 2 things. Number one, you would have seen some urgency in reconstituting IEBC. Some of the petitions that are before you or that will find your way to your hands are also saying the President cannot do what he's so desperate to do because there is no IEBC. So that is coming. So if there was any urgency, anybody who cares about vacancy, let us start with IEBC. Now, Lord, also, if, and I think Kenya are entitled to this information, Mr. Kamodo appears sorry that a vacancy in the office of the President may arise. Perhaps this is information the people of Kenya are entitled. Why is that so?
My Lord, it's purely conjectural. It's an
Right, I'm not saying anything I've ended there.
Unless you have some...
I don't know. I didn't say it. I didn't say it. Yes, my Lord, now coming to the main issue. My Lord, this forum, somebody said we are sitting past the desk. It made me remember something. I think I saw the presiding judge was practicing at some time when I was practicing as a lawyer in the 1990s. I remember going to court very many times with Dr. Kaminwa, Paul Muite, and Gibson Kamau Kuria. What was it all about? My Lord, during that time, and when we could go to those cases, there was no distinction that was made.
My Lord, with the very kind permission, I'm constrained to just want to get some clarification. The application?
No,
because the role you have, you know it, you are supposed to be responding to issues that have arisen. I don't think what you're speaking to has arisen, and there is no latitude that extends to that in that general direction. Yes. My Lord, we would want to get some guidance on that.
My Lord, I believe those issues...
You made the clarifications earlier,
yes,
but now just stick to the reply according to...
I'll do that. My Lord, one of the cases that during that time, because you can't address every little issue, I'm trying to be global. My Lord, one of the, and this is a global point I'm making with regard to the issues that have been raised. My Lord, you are effectively being told the petitioner and the respondents occupy the same space from the standpoint of our constitutions. My Lord, the truth is they don't. And I say that for the simple reason that these constitutions of Kenya was made explicitly to protect citizens who can suffer from harm from the executive and people who occupy power. That is what the protections are meant to do. Conservatory orders are given to ensure people whose rights are being violated and in need of protection, that protections will be accorded. So somebody to say that an application for conservatory orders stays on the same level with an application by a violator to continue or to complete the violations, my Lord, that would amount to misreading the Constitution. And this is not an idle issue. Under Article 20, it is very clear. The Constitution binds all state officers and this court. So the notion that we have a right to be heard, yes, when we shall be doing the petition, give them 10 hours and we shall not object. But let the subject matter be preserved. We've got no problem. The right to be heard under Mutunga rules is protected. But there is a distinction under our constitutions between a violator and the victim of violations. That one is very clear in our jurisprudence. Well, having said that, there is an oath of office. There is a question of the empanelment, whether you call it assignment, appointment. The issue is, for purposes of Article 165 of the Constitution, does the Chief Justice exercise judicial or administrative powers? I go with what Dr. Kaminwa says. These are judicial powers. And judicial powers, my Lord, takes us to the oath that is prescribed by believing the third schedule of the Constitution. When the Chief Justice says, takes an oath, it to exercise the judicial powers that includes, with regards to the High Court, the powers under Article 165(4) of the Constitution. No such oath is taken by the Deputy Chief Justice to enable her to do so. So that, my Lord, as long as, if you say it is administrative, we go to another level. The questions would be, can this be made without a formal judgment where the issue has arisen directly? Because as we were told by my learned colleague, Mr. Waduta, that matter is still yet to be decided by the Court of Appeal. My Lord, having said that, there is a question, my learned Professor Muigai, whom I learned a lot from him. But Professor Muigai talks about public interest, the issue of the necessity for it, and about a vacuum arising. But the happy thing about the Constitution is that up to this time, the petitioners have done nothing that would elongate the time at least of 74 to 100 days that is envisaged under Article 149 of the Constitution for this business to be conducted. If anything, it is this kind of applications to set aside that will prevent these petitions from being heard, for example, in the next 30 days, so that there is still some other 30 days for the people of Kenya to be consulted on this issue and the regular decisions to be made by Parliament. My Lord, there is an issue that an absurdity is being created. Who is creating an absurdity? The absurdity, my Lord, that is being created is this. And strictly speaking from Article 25 of the Constitution. Article 25 of the Constitution says the right to be heard is absolute, even during an emergency. How can this right ever be absolute, and this court were to take away the subject matter before that right is exercised, and you do not call that an absurdity? We are actually here to prevent that absurdity. In fact, you can have a ranking of absurdity. The biggest absurdity, my Lord, would be this, Article 125. All rights under Article 24 can be limited. Under Article 25, the right to be heard is absolute. It is binding on everybody. That's the biggest absurdity that can occur. Who supports that absurdity? The respondents. My Lord, we go next to Professor Ojienda. Of course, Professor Gedu said many things which you cannot deal with all of them. This internal memo, where is it? Oh, it's here. My Lord, this internal memo, first of all, we note, when the question was asked, is it anywhere? It is not in the CTS. Start one. Number two, or portal for the cases that have actually been filed. My Lord, the second issue, there is no replying affidavit for this court to be able to deal with it. But what does it actually say? It says, during my absence, I request you, your lordships, to be in charge. I will, however, be available on email or telephone for consultation. My Lord, the last sentence, plain meaning of English, would mean to me that Chief Justice from Geneva or anywhere else she was cannot be able to carry out certain administrative functions. But when she says that to be consulted, this was clearly made in the knowledge that there are certain things that I must do, notify me so that I can do them. The appointment of judges could be made by the Chief Justice in accordance with the constitutions from Geneva. My Lord, I could have said more, there is not much time. My Lord, they say they are challenging ex parte orders. My Lord, what ex parte orders is the main issue. The ex parte orders we are challenging is a conservatory order to ensure that before this court there will be integrity and the constitutions will be upheld. And the kind of circus we had in Parliament will not happen before you. My Lord, for purposes of where do we want this matter to be completed? My Lord, they said that they want the matter to be completed. We are more desperate for this matter to be completed. And that is why in the expectation of the petitioners, we expected that the first business of this court, like it happens every time I sit on benches, and I've sat on very many, they say, this matter is very urgent, we cannot hear preliminary matters, let's go straight to the petition. So we are very desperate to have this matter heard. My Lord, there is my learned colleague, Mr. Nyamodi, whom again is a good friend of mine I respect. CJ occupies 3 constitutional offices, I agree. But the only issue of distinction is, under Article 165(4) of the Constitution, she cannot be able to perform that functions any more that we could say she could transfer judges. Transfer of judges is actually more or less administrative, but she doesn't do it because it is an important office that goes with the office of the Chief Justice. But if this is judicial, she cannot be able to do it. My Lord, the issue of Conchela, again, the issue is contextual. The Chief Justice was a party, and therefore in Conchela, as far as I am concerned, the matter, the Deputy Chief Justice did so as an acting Chief Justice. Even Gachagua or anybody else who gets into that position, when they are acting as acting president, there are certain decisions that they can make, but they must wear that position. In this letter, there is nothing that suggests that the Deputy Chief Justice was turned into an acting Chief Justice by the CJ. Equally importantly, there is no express delegation that my powers under Article 165(4) would now be performed by the Deputy Chief Justice. My Lord, the issue of Gumbo came with some funny issue on concealment of material facts. I do not know. I struggled to listen that we have concealed anything. Now, as anything, we actually even did an affidavit. They had the right to do an affidavit. It is not indicated that this document, which was in our possession, as I understand the law of disclosure, we failed to disclose it. All the other issues they are raising are points that are in contention. That does not amount to concealment, as I understand it within the law. My Lord, there was the question that no basis for Getonga Murugaro. Getonga Murugaro, I'm trying to rush. Murugaru? Okay. Murugara, okay.
That's very
sorry. Oh, that's okay, my friend. My Lord, he says, and I agree with him, that this matter is very important for the 50 million Kenyans. I could not agree more. A matter that is so important to 50 million Kenyans, the least that could be expected is that proceedings are going to be conducted in open, without suspicions, without undue hurry and pressure. But my Lord, if the petitioners, and already they are feeling, I'm feeling pressure that I started today, if the petitioners feel that they are under pressure in a certain matter, that is not an express emergency under the constitutions of Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the Constitution say you should do it within around 80 to 100 days into 4 hours, there's a big problem, and that must be addressed. I'm about to finish. My Lord, so that for purposes of those issues, I agree with him. It just points out to the care that must be taken that these proceedings are not misunderstood. This court in particular must not be understood that it was under undue influence, that we must wear somebody Wednesday, Thursday, or something like that. This must be done within the 4 corners of the Constitution. If that one is not done, my Lord, there would be a huge problem, not just of perceptions, but the huge problem that in Githongori versus Republic, they were talking about. The world, Africa, and everybody else is watching. And what are they watching? How are we going to consider to reduce time, for example, that is expressly set out the Constitution into hours? And to do what? To prevent a victim of constitutional violations from urging petitions that are before the court. That should worry the court more. 2 points that are remaining. Mr. Wanyama, I have to choose between Wanyama. Oh, Wanyama is the last one. My Lord, the issue of Wanyama is national stability. He made several points. That is probably the only one I will address myself. Mr. Ngoya can do the rest. This issue of national stability is actually very important. I agree with him. The issue of the impeachment of the deputy president raises the issue of national stability. For the simple reason, and this is why we must hear the petition, the deputy president, my lords, and as we understand elections in this country and the Political Parties Act, was not just a holder, the way you can appoint Kibe Mongai to be a legal officer somewhere. He was not just a holder of the office of deputy president. There was a political process in order to be able to get power under the Constitution in the 2022 election. That's why the national issue of national stability arises. His supporters and also the president, they came together to form a party. So that, my Lord, over and above, and there is a case which I was privileged to do in 2013, one of the lawyers in that case, this one of conflict management, when Ruto and Uhuru were being prevented from running for presidency in 2013, that case, my Lord, and we did it before 5 judges, it was civilized, it was decent, there was no hurry. But more importantly, what was the issue there? Part of the issues that I was present in that case to urge is this, that President Uhuru and the now President Ruto are not seeking this case by themselves, because Article 38 of the Constitution says they are doing this. The peoples in exercise, their supporters, in exercise of their right, political rights and Article 38, prefer these people to be their candidates. So what's my point? My point is this. Look beyond Rigathi Gachagua. Look also to the people who feel we've not been given a square deal and we are being disenfranchised, we are being emasculated from the political scene. We shall urge that more during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring so that we can meet sometime next week, my Lord, and deal with the issue. My learned colleague, Mr. Ngoya, can take on from there. No, my lord, I have finished. My landed colleague, Mr. Ongoya, to say something.
My lords, my lady, I just have a few points to highlight.
Regarding Gachagua. Hii serikali tulitafuta na shida mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo ikulu nimeweka mitego kila kona. Hapo iko kibarua.
291 members of this National Assembly pended their signatures in support of this motion.
Crowned by Skytrax, 15 years in a row. Yep, we've taken over 500 million of you to places. All thanks to our dedicated All-Stars and you.
Sikia. Ni juicy. Flavor zote tamu tena fruity. Are you bored? Kuna vitu. Ay. Kituka na shika. Yummy na flow kama maji. Tena fruity. Are you bored? Kuna vitu moja juu ni tamu kama sali. Ni juicy. Flavor zote tamu tena fruity. Are you bored? Kuna vitu zinakuudhi. Sijali my bro. Hebu kama taka juicy juu ni juicy. Flavor zote tamu tena fruity. Are you bored? Kuna vitu zinakuudhi. Sijali my bro. Hebu kama taka juicy juu ni.
This is the comfort of a mom's hug. Nahi ni Morphix Spans comfort that feels just like a mom's hug. Babies play around and then, oops, Morphix ina absorb like whoop. Imagine, haiwezi live in 50 different movements. Makofi to both babies and Morphix. Renewed Morphix, ultimate quality.
Morphix is renewed. Improved Morphix quality, now in blue package.
Acne-prone skin, marks? Stop. Try new Garnier Charcoal Serum with 4% AHA, BHA and charcoal. The first black serum with no residue. Clinically proven to reduce pimples and acne marks. New Garnier AHA, BHA Charcoal Serum. Approved by dermatologists by Garnier Naturally.
Those who are 45 years and below were required to automatically join this scheme. And then they were given the option. For those who are above 45, were given an option to make a decision whether they would want to join. Now we are talking of having a membership of 443,000. From zero start in 2021, no assets, to now we have assets that are actually supposed to meet the benefit requirements of these 443,000 members, which starts at the tune of 57 billion. We allow some investment in government securities. We have put part of it in quarterly equity, and quarterly equity we are also thinking of diversifying to private equity funds, and we are also coming systematically to property investment.
Acne-prone skin, marks? Stop. Try new Garnier Charcoal Serum with 4% AHA, BHA and charcoal. The first black serum with no residue. Clinically proven to reduce pimples and acne marks. New Garnier AHA, BHA Charcoal Serum. Approved by dermatologists by Garnier Naturally.
Unahitaji msomaji habari aelewaye matukio na matokeo ya matukio?
Michezo hutegemea hewa safi.
Msomaji habari mweledi wa majimbo
katika kaunti ya Turkana.
Msomaji habari mweledi wa masuala ya kanda.
Nataka nisikie vile wewe kwanza unasikia.
Msomaji habari mweledi wa masuala ya ulimwengu.
Hapa jijini New York nchini Marekani.
Msomaji wa mtagusano, mvuto, mnato na haiba ya kuaminika. habari zako za NTV ya dhuhuri zimepata sura mpya.
Mimi ni Lois Wangoi. Kila siku, kila wiki, kila tukio. Saa 7 adhuhuri kwa taarifa kuntu, tendeti na za kuaminika ni NTV adhuhuri.
Acne-prone skin, marks? Stop. Try new Garnier Charcoal Serum with 4% AHA, BHA and charcoal. The first black serum with no residue. Clinically proven to reduce pimples and acne marks. New Garnier AHA, BHA Charcoal Serum. Approved by dermatologists by Garnier Naturally.
Global Tea and Commodities Limited is by far the largest tea exporter in Kenya and probably in East Africa as well. Our group has employed close to 1,000 employees. We face so much of challenges. One of the rainbows in the storm has been Apsa's TMO system. The facilities which we enjoy has helped us grow our business in the last year tremendously. And together we can write the next chapter of our story.
This is NTV.
As matter of principle, saying that things have not been done properly. And it's because, my Lord and my lady, Kenya is an interesting country. There is a book here which I read from time to time, the Constitution of Kenya Commentary. The Constitution of Kenya Commentary. There is a sentence in this book which is very disturbing. It says this. I'm sorry, I came in late in this matter. I would have been able to go through and flag a particular sentence. It is, there's a sentence in this book which says this. Kenya is one of the most corrupt countries in the world. In this book, it is written there. Kenya is one of the most corrupt countries in the world. And my Lord and my lady, suspicions are cast on the National Assembly. Suspicions are cast on the Senate. And my Lord, we appear before the Lordships and my lady. When suspicions are cast on this court, we stand up and protest loudly. All that you are urging very respectfully, my Lord and my lady, let this matter, when I quote what my land friend has said, let this matter go back to the Chief Justice. If he endorses you, he recommends you, we have no problem. She would have done her work properly. But let things be done in a proper manner so that we do not send out the wrong signals, so that we do not send out the wrong perceptions that there is corruption going on in National Assembly, in the Senate, and in the Judiciary. Let the matter go back. Now, it was said to you that there are certain individuals who are above the law. That's not correct. When you are appearing before your lordships and my lady, we should show that actually we are really learned in the law. All of us, as my land friend, Mr. Kiba pointed that quite properly, all of us are under the law. The judges are taken to court, the Chief Justice can be taken to court, the Speaker can be taken to court, the President can be taken to court. And in fact, the case of Trump versus Vance, a United States court, 9 Supreme Court judges made it very clear that the Director of Criminal Investigations is at liberty to investigate on the President of the United States. It's my humble submission that I shall be advancing the same argument, that in this case of Gachagua, no Director of Criminal Investigation was called or summoned to give evidence. Am I wrong, Mr. Mitchell?
No, you're correct.
I'm right. Thank you. I'm glad I'm still bright. No director of criminal investigation was summoned to give evidence. This is a lacuna. This destroys the whole case. My Lord, there is something else I would like to say to you, very, very respectfully. Conflicts at work. We are always quarreling with people we work with. It's normal. I happen to know that Chief Justice Miller and Sir James Wilkes never got on very well at all. They quarreled from time to time, but they couldn't work together. I happen to know Chief Justice Trevelyan and Justice Martin were not friends. They used to throw some things against one another, but they continued to work. Some of us who have been married and so on, we know that actually at times a wife can quarrel and at times a man can quarrel, but they still continue to live together under the same roof to make sure that the children actually have a parent, father and mother. And that's what we are saying. This nation has to survive the crisis. We cannot destroy the nation by saying because of president and deputy president quarrel. That is very, very naive way of looking at life. On that note, may I say thank you very much, and I shall be advancing the argument of alternative dispute resolution. I put them on notice. We shall be advancing the alternative dispute resolution. We can get presidents like Museveni, we can get our Archbishop, we can get our retired Supreme Court judges to sort them out and continue to work. But we cannot abandon the Deputy Chief Justice because the two of them could not get on well. That is a very, with respect, that's a very childish way of approaching this matter. Thank you. By the way, I have a book here that I can donate to you to end our presidency. Oh, thank you. May I say I'm very happy that your Lordship reads so widely.
So Senior Counsel Paul, are you responding?
No, my Lord, in the interest of time, we'll go along with the submissions.
Then we can give you 1 minute.
Just 1 minute.
And then again.
Yes, Kimoto, Teresina, and Jiro. The notice was not necessary. And wrong time. The reason why we are saying this is that the Chief Justice, though we are being told you have been given a memo and directed to the portal, which I have checked right now, and it's not there. The last thing that was there was a ruling delivered by Honorable Richard Mwongo at Kerugoya, and there's nothing else. So the Kerugoya matters, they have nothing else there. And we have been told this internal memo was filed at petition E14 of 2024. So that is not true. However, we wish to say that once a court sits on Saturday, and then at a wee hours, it could look like a good thing, but then a wrong thing. Because the perception people will have is that there's something fishy going on. That is what we are crying out loud and saying it is not necessary. And the last thing that I wish to note is that justice cannot be served expeditiously while infringing the rights of others. So we are very much in order. Fair hearing is a must. And we cannot be told it's for the interest of quick delivery of justice that we infringe other people's rights. So we are saying, let us be heard fairly, and we be given enough time to respond to all the motions that are before court, and also the petitions or the responses filed, so that we cannot be prejudiced. That's all.
Your Lordship, with your very kind permission, my name is Sakimpa. I just have one issue to respond, and that is by Professor Gidu Muigai on, Your Lordship, Professor was so precise as to the time when the file was transferred from Kerugoya. That is at 3:45 p.m. Your Lordship, I have also taken the liberty to look at the order that was issued in that matter, and it was the order was issued at 3:37 p.m. So in 8 minutes, Your Lordship, the petition E015 was transferred, or rather was transferred to the Chief Justice. Your Lordship, in our matter, that is petition E014, it was transferred to Her Ladyship on 11th of October. So those are 8 days. Your Lordship, therefore, we don't understand why the expediency that came in the sense that one petition is transferred to the CJ in 8 minutes, while our petition takes up to 8 days for it to be transferred.
I think the petition which was filed in Karagoya, the lawyers who did that yourselves,
yes, Your Lordship,
should answer that question.
Your Lordship, and that's the issue.
That is your question to answer. You cannot pose it to us.
Your Lordship, it's in the context of the matter in which...
Yeah, you must balance all issues. You don't, when an issue favors you, you want to raise it up. When it doesn't favor you, you want to put it down.
I'm well guided, Your Lordship.
Each orders which came from Karagoya by your orders.
Yeah.
Thank you very much.
Thank you, Your Lordship.
Thank you very much. Before we make final orders, please keep quiet. Before we make final orders, we as a bench, we want to thank all counsel for the mature way in which we have conducted these proceedings, and the legal arguments which we have put. They are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Perhaps before you pen off, there could be a possibility, Your Lordship, that it is imperative that we have the other files that were not before you coming up for a mention tomorrow, because there is an application for your recusal that I have filed. I would perhaps also wish to seek directions on it.
May it please the court. Once more, my name is Dr. Eboso, and I'm still beseeching the court that there are other petitions that were filed on this same matter, and which applications were made, including temporary injunctions, but were not given, and which it would be good use of judicial time if the petitions and the applications therein were heard together with the applications that are in this matter. And I would like to point out that if this bench, which is a high court, proceeded to hear the issues that surrounding the conservatory orders in this application, the 3 applications that are before this bench, absent the participation of the applicants in all those other files which have already been filed, we would suffer prejudice, because we would be arguing applications after the court has already sat, and we would be reinviting the court to argue the very same thing. So I would wish, as the court retires, to consider that. Thank you.
Okay. Before the addresses, I just want to make this clear again.
Yes.
Will not deal with any file in which we have not been empaneled. If you file a petition and it is yet to be empaneled, it is upon you as counsel to follow it up with the deputy registrar of the court. First of all, you may have to ascertain whether you applied for empanelment, because it's not automatic. If an order for empanelment was made, follow it up. That is the only time you can know what happened. When the file is empaneled, it comes before us, we will deal with it. For the matters which were empaneled, and maybe they are not here, we presume they are not before us because we were not moved. We have handled the matters today because we were moved by an application. If you feel we need to look into that matter expeditiously, you may have to consider. But at the appropriate time, we will issue comprehensive direction on all the matters which were empaneled with, which we were empaneled, even if there will be no applications. So let us get it clear so that as we move forward, we avoid this back and forth of getting us back to matters which were either paneled or not paneled. Let's be focused. We will deal with every matter, but now we are dealing with matters where we have been formally moved. Thank you.
Yes.
Thank you. You are welcome, and we do thank you for holding the flag of justice for common.
My Lordships and my lady, on behalf of the respondents, I want to thank you for according us notice. I want to thank you for your patience, and as the titular head of the bar, I want to encourage my learned friends that we must continue being respectful, professional, and holding the dignity of these courts very highly, and protecting the dignity of the courts and the dignity of our country. Thank you so much, and have a blessed evening.
Thank you.
My Lord, may I, sorry, I like talking. My Lord, may I say that I am most grateful to the remarks of the Honorable Lady Attorney General. And if I may say so, with respect, in the most recent times, she has shown that the courts must be respected by herself personally appearing in court. There are some previous attorneys general whose name I would not like to mention, but who are full-time officers, workers. Thank you.
So we reconvene tomorrow, the 23rd of October at 3:30 p.m. Thank you.
My brother, it's been a long time. Did I see you after I became a G? And I need to say, don't congratulations, I didn't get the opportunity. You know we were with you for many years. Okay. Sasa. The constitution is upstairs. I have to come. You know, sikukuja when it was wrong. You know, I was not there when it was wrong upstairs.
Sniper bwana. Unaingia kisniper nianze. Hivi ndio tunaendanga bwana. Hata kwako tunaweza ingia. Tuanze kusonga. Nichukue ile microphone tafadhali.
Wewe unatoka hapa. Unipigie hiyo picha basi. Ndio. Tunalita. Oh, MTV, we met something there. Was this thing like? Oh, so wananchi knows the problem. And these things you
Ngoja nione nipige nje. Nione nje vile iko.